Hello.
Uh,
Hello.
Good morning, sir. Good morning, sir.
Can you hear me?
Yes, sir. Yes, I can hear, sir. Yes. Is Professor Betsy Raja Singh? She is here, sir. So,
Hello. How are you?
yeah.
Hi, sir. Thanks for having me.
Yeah, we also thank you being here. So,
Just 1 minute, sir. Just I will.
yeah, no issue. Already 19 people have joined.
Good morning to all of you. I think we'll start the webinar. So I request our director, Professor Basant Kumar Pradhan sir, to give his welcome remarks.
Thank you. Good morning to you all, dear colleagues and students. It is a pleasure to welcome you to this webinar on intellectual property rights in the artificial intelligence era. As you are aware, artificial intelligence is affecting almost every facet of human life. The generative AI has made a profound inroad into teaching and research, thinking and acting like humans. It is transforming education by enhancing the quality of learning, improving administrative efficiency, and driving innovation. It is creating personalized, adaptive, and engaging learning experiences for students, and has improved the productivity, efficiency, and decision-making process for educators and institutions. Similar things are happening in the research front. It is improving efficiency by leaps and bounds. But simultaneously, like any other technology, but with a much higher scale, it is bringing in unprecedented challenges, academic, ethical, and legal. It has presented a significant challenge in protecting intellectual property of authors, publishers, and other creative people. Generative AI can create works that blur the lines of traditional authorship and raise questions about copyright in scholarly works. In this context, our library has organized this webinar, and I hope you will get enough insights which will help you to protect your own work. What are the key challenges? A major question is who owns the IP rights to works created solely by AI, as the AI system lacks legal personhood. Many jurisdictions, including India, adhere to the principle that copyrights applies only to works authored by humans. This raises questions about how AI-generated content, which may lack a human author, can be protected. The use of AI to train and data scrap from the internet raises concerns about fair use and potential infringement of copyright and other IP rights. The use of AI in IP raises ethical concerns. including the potential for bias, discrimination, and erosion of human creativity. So, the intersection of AI and IP rights is much more complex and has significant implications for scholarly work. Hence, in order to educate teachers, researchers, and students, this webinar has been organized as part of Institute's IQAC activity. Once again, I welcome you all to the workshop and thanks for participating. My special thanks to today's speaker, Dr. Betsy Raja Singh, our librarian, Dr. Pujar, and Assistant Librarian, Dr. Reddy. Let me conclude with the hope that you will all have a fruitful learning experience today throughout the lecture. Thank you.
Thank you, sir. Thank you very much. First, on behalf of IGIDR, on behalf of Director and Registrar, and all of us, we welcome Dr. Betsy Raja Singh for this webinar. And just give a brief introduction before she starts her speech. So she is currently working as an assistant professor of law at the National Law School of India, University, Bangalore, and where she is LLB program chair and also as well as co-director of the Center for Intellectual Property Research and Advocacy. And she has pursued her legal studies at the Dr. Ambedkar Government Law College, Chennai, where she graduated as a college topper and pursued her LLM in Intellectual Property and Technology Law at the National University of Singapore as Miranda Scholarship Awardee. Intellectual property law is her principal area of research, teaching and research, which led her to studying the implications of technology and law on the limits and exceptions to the copyright related to education in her PhD. The study further resulted in publication of a book titled Digital Copyright Law, a comparative study of limitation and exceptions relating to education with Thomson Reuters. She has also previously worked as legal executive with Joyce A. Tan and Partners Singapore, a boutique IP firm, and has taught and practiced the law in Chennai. Thank you, madam. You are welcome to this.
Thank you so much for the kind introduction and the invitation, sir. I look forward to this lecture. So I will share my screen now. I hope it's visible.
Yes, madam. Yes.
Right.
Yeah. Thank you.
So it's great that we had a good introduction from the director who spoke about AI and copyright in particular, because this particular lecture is going to revolve around the topic of AI and copyright, specifically the issues and challenges surrounding AI and consequently the copyright issues per se. So this is something very relevant today and very current as well, because we know that AI is a big industry. So I hope that through this lecture, you are introduced to some of the very prominent issues relating to copyright in the AI spectrum, particularly with relation to authorship and fair use. So if I could just give you a roadmap, this is how the lecture is going to be structured. I'll give you a brief primer on AI, as well as what copyright is, and then lay bare what the issues surrounding AI and copyright are in the current context. And these issues more specifically are authorship and fair use. So within the context of these issues, we are going to look at specifically some judicial precedents from the United States, as well as we'll look at the Indian law and try to understand what the fundamental issues surrounding authorship are, as well as the fair use defense in the context of AI. More specifically, we know that AI is quite broad, so it's going to be very specific with relation to generative AI. Now, as I initially said, AI is a big industry. Now, this quote will help you understand how big it is. So I'm going to start by reading the second part of it on the economic potential of generative AI. The consulting firm McKinsey, this is sometime in 2023, so the figures might have grown right now, estimates that generative AI could add the equivalent of 2.6 trillion to 4.4 trillion annually across the use cases we analyze by comparison, now these figures, if you compare, it's almost equivalent or even more than the entire GDP of the United Kingdom, which stands at 3.1 trillion at around 2021. So you know that AI, generative AI more specifically, and the kind of income that it generates is huge. So the creative economy is one of the biggest and most important in the world. If you had followed the news yesterday, Mark Zuckerberg announced that there is an app that is launched with reference to Meta AI. So AI is ever evolving, and today is one of the most hotly used uh, platform as well, to not just generate content, but all types of other materials as well, which might be subject of copyright. So therefore, though this is a huge industry, there are invariably implications for copyright law more specifically, which we will help understand in this particular session. So if you look at the definition of AI, I'll start off with what AI is briefly in this slide, and then have a brief discussion on what copyright is. And then we'll look at the intersection of AI and copyright and the specific issues pertaining to copyright in the AI era. So if you look at the definition of AI, the Encyclopedia Britannica tells it's the ability of a digital computer or computer-controlled robot to perform tasks commonly associated with intelligent beings. So invariably, there is machine learning involved, and deep learning as well to a large extent, where systems that are developed can basically learn and mimic human intelligence, right? Now, these are AI systems, and these AI systems uh, do a multiple kind of roles in various industries. So be it diagnostics in the medical industry, or other types of AI in engineering industries. We have AI which features in almost a wide array of industries, as well as in our day-to-day life as well, like Alexa and other types of AI are also there, which help us in our day-to-day activities as well. But something that is more pervasive today and more used is a generative AI. And we know that because this is artificial intelligence, and it's mimicking human intelligence, it's capable of learning, adapting, and constantly improving itself, and generating content. Now, generating content is what is primarily something which will be bringing copyright issues to the fore. So we know that AI is capable of generating all type of copyrightable subject matter. So this takes us to the next question. If we say that AI is generating a lot of copyrightable content, what is the subject matter of copyright? And what is this copyright? What does it protect? So if you look at copyright and its subject matter, as I said, AI generates all these subject matters. And these are the protected categories of works under copyright law. So you have literary works like books, dramatic works like plays, and artistic works can include even your photographs, sculptures, paintings. And then you have musical works, which are compositions, and sound recordings, which are actually the recorded music with accompaniment and everything, as well as movies or films, which are also called as cinematograph films. Now, all of these are subject matter of copyright, which means if any work falls within these categories of works, then it can be capable of copyright protection. So where is this subject matter mentioned? Where is it defined? You find mention of subject matter in the copyright law. So for instance, in India, we have the Copyright Act of 1957, which mentions all of these subject matters and suggests that these are uh, subject matter within which, if a category of work falls, it will be capable of being protected under copyright law. But this is just the categories. in terms of whether it can be copyrightable work or not, there is a criteria as well, which is foundational to copyright. Because even though it might fall under these categories of works, if it doesn't qualify as a copyrightable subject matter or a copyrightable work by way of compliance with the criteria, then you do not have protection. So what is this criteria? Criteria is foundational, as I initially mentioned. It basically states that what is copyrightable should be an original expression. Now, each of these words are important. So it should be an original work originating from the author. So originality is an important requirement, as well as it should be an expression. Now, what is this expression? Is it different from an idea? These are things that we will better understand as we progress through this session as well. But ideas are distinct from expressions, and copyright only protects the expression, not the idea per se. So two people might have the same idea, but the way you put down on paper might essentially differ. For instance, you are listening to this lecture, right? And if you are taking your own notes based on what I'm saying, uh, the persons who are attending might each have different expressions through which you have expressed, or rather taken down your interpretation of this lecture, right? Now, each of that can qualify as an original expression and therefore can be copyrightable subject matter. And because you are writing it down, it also fulfills one other requirement of copyright, which is the a fixation requirement. So fixation means you're putting it down in tangible form. So either you're typing it on your computer as notes or you're writing it down. The moment you put it on paper or type it down, it takes a tangible form. It is fixed and therefore capable of being protected. So this essentially implies that spoken word cannot be copyrighted. It has to be fixed. So as long as this criteria of originality and the original expressions coming from the author are fixed, they are capable of being protected under copyright law. Now, apart from the criteria and the subject matter, that is the categories of works that are protected, what does copyright essentially guarantee to you? It gives you a set of rights. So I started off by saying that you can have copyright over the notes that you're taking down in this lecture, right? So if these notes are original expressions and because they are fixed on paper, you have copyright over it. Now, what does it imply? It implies that you have a set of rights over what you've just written, or you might have drawn a piece of painting or painted a piece of painting. Now you will have copyright over this work. When I say copyright, it means some set of rights, right? So the statute or the copyright law tells you what these rights are. So because you are having a property style right, that is a copyright over the work that you're creating, which can be a song you sung or a lyric you've written or the notes you've taken, what corresponding rights do you get out of it? Now, these rights can be economic and moral, but we look at the economic rights because you have created a work which is original, which is fixed, and which falls within the categories of protected works. What you can do with this, because you have a copyright, is a set of economic rights, which includes the right to make copies. So you can be the only person who makes copies of this. So say you publish a book, and with the publication of the book, you have copyright over the book, right? Which means you will be the exclusive person who can make copies. Now, we know that publication of books invariably is not always done by authors. There is a licensing agreement involved with the publisher. So the publisher publishes. Nevertheless, if you retain your copyright or if it's transferred to the publisher, the owner will have the right to make copies. That is reproduction. That is a right. Similarly, he will have the right to transmit it online, which is the right of communication to the public. Similarly, the person who has written the book and or the person who correspondingly holds the copyright, might be the publisher or the author, will have exclusive rights to adapt this book, say, into a movie. That is called an adaptation right. Now, all of these economic rights are given or guaranteed to the copyright owner. And as I said, because these are property styled rights, these can be transferred. Just like how you would sell a car or a piece of land that you own, your copyright can be very much sold as well. So in copyright parlance, we call it assignment. So you can completely transfer all copyrights or the economic rights that are listed under the act, which I just mentioned, to someone else. So you can, as an author, transfer all copyright to the publisher, or you can retain some rights and transfer some rights alone. So even partial assignment is allowed. And similarly, um, apart from transferring rights through sale or assignment, you can also license certain rights, which means you will retain ownership, but you nevertheless license certain economic rights alone, like the rights license to maybe make copies or sell your work, right? So these are transferable. And because you own a copyright, it does not mean you have eternal rights over it, but there is a fixed term for copyright. For instance, if it is a book in India, the author will have copyright for his lifetime plus 60 years. So that's the term of the copyright within which you can exclusively exercise the economic rights. So within the term of copyright, you will be the only person to make copies and sell it. But after copyright expires, that is 60 years after the death of the author, when the copyright expires, it falls into the public domain, which means this information right now is free for everyone to use. So anybody could make copies, anybody could sell these copies, as well as we could engage in other adaptation, translation, or any other right that is listed as an economic right under the copyright law. So this is a brief idea about what essentially copyright is, what is copyrightable, what are the categories of works, as well as what are the corresponding rights you have and the term of these rights. Now, with this introduction of what AI is and what copyright is, we'll move on to the specific questions pertaining to AI and copyright. Okay. Now, these are some foundational important questions that are at the intersection of AI and copyright. Can AI generated work receive copyright protection? This is the first question. So if a work is created by AI, is there any room for copyright protection? If the answer is yes, who would own this copyright? That's the second question. And if you're saying that there can be ownership, then who will be the author of this work, right? Because when you're saying a generative AI work is capable of copyright protection, the immediate question is who will be the author and correspondingly the owner of this work, because is it the person who built the AI? Is it the AI itself which will be the author, or is the person who gave the prompts who will be the author, right? All of these are questions for which we would need to find out answers. Then you have the fourth question, which is relating to fair use. So is it copyright infringement to use protected works to train algorithms or to create AI generated works? Now, we all know that generative AI works on the basis of being trained, because there is invariably a training data set which is used to train these AI models or large language models. And therefore, by way of usage in this training and also correspondingly the creation of works, is there any scope for copyright infringement? So we'll try to find out answers for these questions in this specific session. Okay. Now, the first set of questions revolves around the topic of authorship, and the last one was around the infringement analysis and the possibility for fair use exceptions, right? So we look at authorship first. Now, with reference to authorship, can you classify AI related works to entirely AI generated and AI assisted. So if you're able to make a distinction between entirely AI generated and a work that might be AI assisted, uh, then can AI assisted work qualify for copyrightability because there is substantial human intervention there and it's not entirely the output of the AI system, but there is human intervention in terms of changes or modifications that you might have made, or even the inputs that you had given and corresponding changes as well. So if a work could be classified as AI assisted, then does it fall into a different spectrum? And if it's going to be AI generated, uh, then there is another demarcation, right? So there is some higher level of human intervention in assisted works, but in AI generated, that human intervention is very less. So in both these categories, can you have copyright in the works that are created? Now, this is an important question as well. And with reference to this question, we'll see as to how um, other jurisdictions and India has looked at these categories of works and whether they have suggested that maybe a AI assisted work can be copyrightable as opposed to a AI generated work or vice versa. So we'll try to answer that question as well. As of now, I'm raising a few questions, but we will resolve all of these questions in this session and we'll have answers for all of them as well. So now on the question of authorship, we are looking at the position in USA predominantly, and as I already mentioned, India as well. Now, India, to a large extent, replicates or mimics UK law because we all come from the same common law background. And considering the colonial legacy as well, our laws are largely shaped around UK laws. So in this slide, you see that the Copyright Office of the US has said that the human generated portion of an AI human generated work is eligible for copyright protection. So they are suggesting that an assisted work can qualify for copyrightability. But what will fall within the scope of an AI assisted work is again something that we would have to look closely uh, to understand. So apart from USA, if you look at the UK position, it talks about computer generated works, not directly mentioning AI, nevertheless generated, and says the person by whom the arrangements necessary for the creation of the work are undertaken is the author. So with reference to author, UK statute, which, as I said, reflects Indian provisions as well, suggests that the person who basically made the arrangements necessary for this work can qualify as an author of the work. Now, if you look at this painting, this is entirely AI generated. And it's called A Recent Entrance to Paradise. And this was the foundational picture relating to the case Tallow versus Perlmutter. So if you look at the facts of this case, now this artwork which I just showed called A Recent Entrance to Paradise was created by an AI, which was called Creativity Machine. And this AI was developed by somebody called Stephen Thaler, and he applied to register the work as a copyright work. Now, this again relates back to a question of registration of copyright, right? Because there is an application to register. Now, copyright, unlike other types of intellectual property, is immediate. So the moment you write your notes, you will have copyright over it. You don't have to go register it. Nevertheless, registration is desirable because if you have registration, there is validity that this work is entirely yours, and consequently, you can prevent somebody else from misappropriating it. All right. So people opt for registering it. Nevertheless, even without registration, works are copyrightable. So here you have Thaler who's applying to register his work as a copyrighted work, and basically he is claiming to be the owner of the work, right? And in the application, that's what he is mentioned as well. So while the Copyright Office in the US is processing this application, they raise fundamental objections and rejected, saying that this is a AI generated work and therefore there is lack of human authorship. Now he tries to contest this, and if you look at Thaler, he's also preferred patent cases with relation to usage of AI, and AI being an inventor. So you have his cases before the UK as well as the US registry relating to patents as well. But this is the copyright specific case where he is seeking copyrightability over the AI generated work. And so in his request for reconsideration, uh, he is suggesting that this should be protected as a copyright work, with either him being the copyright owner or the author, or because he's the one who's built this AI itself. So therefore, he should be the owner. And he also suggests that just like how an employer would get copyright over the works that his employee creates, now we have provisions for this as well in the copyright law. So if you're under the employment of somebody and you are creating a copyright work, it will automatically vest with the employer. So he's suggesting the creativity machine is like an employee, and the work that it generates consequently should be his because he's the employer. Somehow the US registry is not at all convinced, and they suggest that human authorship is definitely required for copyright protection in the US, and therefore this particular work cannot be registered in the name of Thaler because it is entirely AI generated. You have a few other instances of copyright applications for works created by AI as well. So we look at them and try to understand what this position in the US is with relation to authorship of AI works. Now, Zarya of the Dawn again is a comic book. And in this comic book, Midjourney is the AI system used to create images. Right. So the author in this comic book has other content as well. So she's written a comic strip in which she's included pictures, and the pictures alone are AI generated. Here again, she applies for copyright for the entire work. Right. And initially this copyright was granted because she had not mentioned that the images was AI generated. But after she announces that Midjourney was the AI system used to generate the images that are there in this comic strip, then the US Copyright Office contacted her asking for details about AI use, and also that they was considering canceling the registration that was granted for this copyright work. Now, pursuant to her response, the Copyright Office clearly states that, look, we can give you copyright for what you've written in that comic work. So for the elements in which you can have copyright, you can. But the images created by Midjourney, because they are entirely AI generated, cannot be subject matter of copyright work. So you will have the copyright without the, or rather excluding the images, because those are not copyrightable subject matter. So this is something that reiterates the position that it had already taken in other cases as well, and very similar to the Thaler decision as well. Moving to another interesting scenario before the Copyright Office in the US. This is again a AI generated image, which actually was a winning entry in a competition as well. So this drawing is called Theatre d'Opera Spatial, and it won this Colorado State Fair's annual fine art competition. So this painting won in this competition, after which the creator of this particular work, Jason Allen, filed for copyright of this work as the artist or the author of the work, right? But this image was entirely again created by the AI image generator Midjourney. So he's suggesting, look, it's not easy to create using AI. If I have to use an AI system like Midjourney to create an artwork, I would invariably have to give substantial amount of inputs to get this final version that is the winning entry. So he is even clarifying and suggesting that he used 624 prompts specifically, including revision of these prompts to come up with this final painting. So it's not that he's given one prompt and he's generated this image. To generate this image, he's saying that there's a substantial amount of work from his end as well, which is in the form of the prompts. So his suggestion is, without these prompts and without my input, this work would not have been generated. So why can't I be the copyright owner of this work? But here again, the Copyright Office outright rejected his request to be registered as the author of the copyright work. In fact, they even cited lapses on his part to disclose and disclaim the AI generated portions, and suggested that the use of AI is definitely not trivial here. It is substantial use of AI to generate this particular artwork, and therefore it will not qualify as human generated and will only be a AI generated work, which cannot essentially be copyrighted. Now, this again takes us back to some of the foundational concepts relating to copyright. Because if you look at the debate that most of these artists or authors have given in favor of grant of copyright, is the suggestion that there is substantial input from their end, without which the copyright work, or rather the work, would not have been created. So because there is human input, take the last example, say 624 prompts, without which this work could not have been generated, and consequently labor and skill should be rewarded, is the argument that they are trying to make. Now, this is at least acceptable to a certain level, because initially under copyright law and as copyright jurisprudence evolved, the sweat of the brow doctrine was what was initially an accepted way of thinking in terms of copyright law, which means as long as you put some amount of labor, whatever you generate is capable of being protected as yours, right? So applying that logic, 624 prompts is substantial labor and therefore it has to be rewarded, was the argument that the applicants were making. But we also know that the current position of law has moved away from that sweat of the brow doctrine. And today, what is copyrightable is something where you should have at least a minimum level of creativity. And this standard was first laid out again in the United States, in this particular case, Feast Publication versus Rural Telephone, where the copyright contention was around a telephone directory. So can you have copyright in a telephone directory which just contains factual information, which is basically the name of the person and the telephone number arranged in alphabetical order? Here, the court in the United States clarified and suggested that, look, it contains mere facts, and there's just this arrangement in alphabetical order over which you cannot have copyright, because though there is labor involved, there is effort involved nonetheless, you do not have a minimum level of creativity that is required to grant copyright. So it laid down the modicum of creativity standard, suggesting that without that minimal level of creativity, you can't basically give copyright to someone. And this was also applied in India, and we have an extension of the modicum of creativity standard in our Indian law in the Eastern Book case, where we've laid out that skill, judgment, and this minimum level of creativity is required for protection of a work as copyrightable subject matter. All right. So using this logic, the 624 prompts might not suffice to uh, guarantee copyright protection. Also, the fact that ideas are separable from expression, something that I began with, suggesting that original expressions are alone copyrightable. Here, the expression is through AI intervention, right? The idea might be yours as to what you want. So you're putting in diverse or rather n number of prompts and suggesting that this is the kind of work that you want, but it's the idea that you are inputting. The expression or the output or the image that is generated is through AI. And how the AI thinks or processes or creates this expression is something which is like in a black box, something that no one knows. So even though I put in prompts, what the AI is going to generate is not something that I could immediately foresee, right? So the intervention of AI is there to a large scale, and the expression is entirely dependent on the way in which the AI interprets your prompts and creates the work. So therefore, on basis of this logic, again, you can say that the expression is only AI's, it's not the human expression. And considering copyright protects uh, expressions here, because the creator of the expression is AI and not a human, you cannot extend AI protection or rather copyright protection to AI works, because the human element is missing in the output that is generated. So in way of summary of the US position and the authorship requirement, if you look historically, they have always denied protection to AI, or rather works that do not have human uh, intervention, right? So it dates back to 1973, their first policy saying no to AI generated works. And then you have in 21, again, clarification that intellectual property and copyright being a type of intellectual property protects only intellectual labor, and it is founded on the creative powers of the mind. So without this human author, you do not have consequently copyright. And not just the position in the law, you also have judgments which have again gone into this question of copyrightability being, or rather, the author being somebody other than a human being. So you have this specific case, which again deals with a work or a book that is being written, and with reference to copyrightability, the author is saying that they were not the person who wrote the book, and it was only the divine intervention through which this book was created. So therefore they want to peg authorship with a divine being as opposed to them. Here again, the quote clarifies and says, look, you might be a tool in the hands of the divine, nevertheless copyright cannot be granted in favor of a divine being who can be an author. It should be the human element which is basically expressed these thoughts on paper. So therefore, you cannot have copyright being granted to somebody who is divine as opposed to an actual human being. So extending this argument, or rather on a similar line, you have this specific case as well, Naruto versus Slater. Now, this is famously called as the monkey selfie case. Now, if you look at this selfie, this was clicked by the monkey itself, called Naruto. And because Naruto was the one who had taken these photographs, but the camera used was Mr. Slater's, who was a nature photographer. And when he tried to claim copyright in these images, Peter sued him, saying that Naruto was the actual author of the work because the photographs were taken by the monkey itself. And therefore, Slater could not claim copyright over it. Here again, when went before the US courts, they clarified and suggested that because at least under copyright statute, um, authorship is restricted to human beings, you cannot make an argument and extend it to non-human entities like animals. And therefore, here in this particular case, it said that by no way can Naruto be recognized as the author of the work. Now, so divine beings can't be, an animal can't be, and the guidance with relation to copyrightability clearly states that authorship in the US context solely vests with human beings. So that's the bedrock of copyright. Without a human author, you cannot have copyright. So that it clarified it outright. And even in its more recent regulations on AI and copyrightability in 2025, it reiterated its stance that in the US, copyright is granted only to human beings and cannot be extended to a AI work. And as can be expected, it relies on the foundational tenets of copyright itself and suggests that this is solely reserved for human authors. Now, coming to the position of India. So if the US position is that only human authors can be copyright owners and authors, what's the position in India? You have section 14, which defines copyright, and it mentions that it's an exclusive right of the author. So author is mentioned in the context of copyright. Now, is this author defined? Yes, it's defined. See, if you look at section 2D of the Indian Copyright Act, it says author is in relation to any literary, dramatic. So you have all the categories of works, the subject matter, and which is computer generated. The person who causes the work to be created will be the author. So you also can see parallels with the UK law here. So the person who creates, or rather the causes the work to be created, if it is computer or AI generated, can be extended to AI, then they will be the author. So without this human element, again, even in India, you cannot have copyright to the AI itself. Now, I initially also mentioned about how basically you can use this work for hire doctrine and suggest that because the AI is like an employee under an employer who's the human being, it can vest the copyright with the human, that is the employer, though it is the employee or the AI which is creating the work. So, on the question of whether we can extend such an argument in India, and can we say that because the AI here is merely like an employee, whatever it generates belongs to the employer who is the human being, which can also be the person who built the AI or the person who basically gave in the prompts as well. So in this context, again, you have an outright clarification from the Copyright Office, which clearly says that only information of a natural person should be provided as author of the work during the copyright application. So author here, even if you extend the work for hire doctrine, will be the AI. It's just that because it's under the employment or you're using that employer-employee relationship and juxtaposing it to an AI and the AI creator, uh, and trying to extend the argument of copyright being vested on AI. The clarification essentially suggests that you can't do that as well, because here, even though you're saying that the employer is the copyright owner, you will be listing the employee or the AI as the author, which cannot be done, because as per this manual, your author of the work should be the actual human being and not an AI. So though there is a distinction between author and the owner, right? Here it's very clear that the author should be human being and not a non-human entity. So therefore, even in India, the position is that with reference to AI generated works and authorship, you cannot extend authorship to the AI itself. Now, this can invoke contradictory viewpoints, with few arguing that extension of um, authorship to AI is justified, while others may suggest it may not. And this can stem from different viewpoints that they have. Uh, so one, you can say that it's copyright itself is there to ensure human creativity, and therefore human is very much relevant. So without a human, you don't have copyright. And you can also argue that when you're giving a set of rights, there is potential for abuse, and there should be some level of accountability. And if you're going to vest copyright in an AI, it can't be held accountable, right? Like a human being. So therefore, you can't extend copyright to AI. And again, the fundamental argument that machines are only agents, it's only the human who controls them, and therefore the machine by itself can't be the author. Whereas there can be others who also can counter argue and suggest that because there is substantial amount of human input in the creation of computer generated or AI generated works, these should be recognized as copyrightable, and the AI or the person who caused this AI to create the work should be recognized as a author of the work. So these contradictory viewpoints are there, but with the legal position, I think the better view as it exists now is that copyright cannot be extended to uh, AI by itself, or the works that AI is solely generated. Maybe for an assisted work, fine, because there is substantial amount of human intervention. But there again, that human intervention should be capable of being separable and seen separately, right? Then the portions where the human intervened, that is copyrightable, but the machine generated is not. But if you're able to separate that in an AI assisted work, then you can argue that it can be copyrightable. And in fact, certain jurisdictions, even like the US, have suggested that in assisted works, you can have copyright as long as this separability is possible. But if it's an entirely human or rather AI generated work, which is completely AI, then you cannot extend copyright protection to such works. So that brings us to the close of the first segment. The second segment, which we will deal with, is with relation to fair use. This will be more brief, not as elaborate as the authorship arguments. Now, if you look at this image, this is a Studio Ghibli image, and we know that Ghibli is right now trending with most, uh, or rather on social media, you have most profile pictures being Ghibli generated art. What is this Studio Ghibli, and basically what are these artworks? Is there any copyright infringement when these artworks are created by an AI? Uh, and this also brings to the fore certain other aspects relating to copyright, like the fair use defense, right? Now, as I said, Studio Ghibli began in 1985 in Japan, um, and it was basically that's where it started, and it generated some super duper hit movies over the years, and it's a fairly successful studio. But today we know it because of OpenAI and the scope that it's given for our pictures to be transformed into Ghibli style images, right? So because there is an entire gamut of copyrightable work already in place which belongs to Studio Ghibli, are images styled like Studio Ghibli animations? Are they infringing the copyright of the uh, original characters? And is there any scope for infringement here? That's a question. Now, with reference to this question, how do you find the answer? So as I initially mentioned, copyright gives you a set of economic rights, right? So you have exclusive rights, which also includes the right to prevent somebody from infringing your rights. So if it's your work, somebody else can't try to pass it off as their own or infringe your rights by making copies, which is again your exclusive right. So all of that is not allowed. And if a work is copied, it'll amount to infringement, right? So if you write a play and somebody makes a movie out of it, and the movie invariably largely draws from your work and you're not acknowledged, neither are you paid for using your work, you can always sue them for infringement of your copyright in that work, right? So there, the question before the court, if it goes to court, will be, has the movie maker infringed your copyright? So they will look at the similarity between your work and the movie. Your work might be in the form of a book. They look at the movie and the book and see if substantial amount of content is taken from your book, right? So they look for substantial similarity. Court has laid down tests there, and based on if or rather if the court is convinced that there is substantial similarity, then a case for infringement will be made out in your favor, and the person who's made the movie will have to pay adequate compensation, damages, right, for using your work without authorization. Now that's infringement. Now, this use can also be non-infringing if it falls as a fair use related defense. So fair use, what is this fair use? It's a defense. So if a work is copied, right, but if uh, the reason that you're copying it for is an exempted purpose or is a fair use, then though you're originally liable for copying, you will be exempted from liability. So you might be infringing, but it might be allowed because it falls under the fair use defense. So fair use is a defense. So in the Indian context, I just wanted to start off with this case where again a play was uh, initially a very successful play by Topil Basi, who's there in the image. Uh, it was a counter drama was written for this play, and the question was, did the second play, the counter drama, which had characters from the first play, was it infringing the work of Topil Basi? So that's the question before the court, and the court here laid down certain clear tests and suggested that uh, in terms of what is taken from Topil Basi's work, the amount that is taken, as well as the purpose for which it's taken, the character of the use, and effect of the use on the market for the original work, all of these factors have to be assessed. And in assessing, the court concluded that the second drama, the counter drama that was written and basically the play that was performed, was not an infringement because what it had taken from the original play was merely some characters. It is just built on the play and basically is a criticism of that original play. So criticism falls under fair use, and as long as these factors in the context of fair use are complied with as well, there will be no infringement. Now in India, we don't just have a fair use style analysis as done in this particular case, but also has a list of exceptions. So if you can because you're most of you are librarians, you will know about the DU photocopy case and how you can make copies of books for the purpose of education. Now that is a exempted use. Libraries also have an exemption for preserving works, right? So you can digitize copies of books in your library for the purpose of preservation. Now here, though you are making a copy, you are digitizing it, and this act is an act of infringement of copyright, you're exempted because it falls under one of the fair dealing defenses under Section 52 of the Copyright Act. So our law provides adequate leeway for fair use and fair dealing. Now, extending this question of fair use defense to AI generated works, how does this play out? So we know that fair use, what the doctrine of fair use is, and what is a fair dealing exception under the law. So if you are basically AI system which is generating content. Uh, we know that, say, Chat GPT, you give in a prompt and it gives you an answer. It seems to know answers to all questions that we might pose. Sometimes, though, it also hallucinates, which means it can bring up citations that are fake or content which is not accurate, right? It does all of that. But to be able to generate that answer, it's relying on some training data. Right now, this training data is the data that it scrapes from the internet, or data that it might be fed with. Right now, these can also be copyrightable material, which means it can very well be under copyright within the term of copyright. If it is public domain material which is out of copyright, it's definitely free for anyone to use. But considering it might definitely be copyrightable content as well, is this training data or usage of copyright content in training your AI, does that amount to an act of infringement is the first question. So by training a AI model, are you infringing copyright? Because it's an infringement question, there is also the fair use defense that you would have to look at. And that's the defense that most AI developers take, suggesting that uh, though copyright content may be used in training my AI, this will fall under fair use defense. And therefore, I am not uh, infringing because it's an exempted use or an exception to infringement. So that's the claim that they are making. Now, that is one level of infringement and fair use defense, but there's another level of infringement as well in terms of the content that it generates. So, training data can amount to infringement or fair use is the first question. The data that is generated through this Chat GPT or any uh, AI generating tool for that matter, uh, does the content that is generated, is that infringing the copyright is the second question, right? So, and is there a fair use defense that can be applicable in the context of the content that's generated is also something that we will have to look at. So for this, what we'll do is we'll just briefly look at a few instances of cases that have been filed and are still litigated actively in the US and in India as well. Now, Anderson versus Stability AI was the first of such cases to be filed, and this was done by 3 artists whose names are mentioned on the slide, and they filed a suit against Stability AI and their image generation tool Midjourney. DeviantArt and other image generation tools like Stability AI as well, suggesting that because they are artists, their works were unauthorizedly used as training data by these image generating AI tools to train the AI in their style of art, right? And it also says that the works that users are generating may also be infringing. So it's not just the training data, but as I just mentioned, even the work, which is the output, can be infringing. And therefore, can this be allowed or not? And so they're basically suing for infringement. They're saying most of our copyright works are infringed by these AI models. First, by the training data, second, by the content that they generate. And therefore, they should be stopped from using our artwork. Now, this is still litigated. At the same time, you have other instances of, say, news agencies like Times as well, alleging that uh, OpenAI and Microsoft's LLMs, that is ChatGPT and Copilot, are generating output that again copies their news articles verbatim. So if I'm going to on a AI generated tool like ChatGPT ask a question with reference to a news article, it's just reproducing the Times article almost verbatim. That is, it's literally copying the content, and this is a case of infringement as well. So there's a suit that is ongoing with reference to Times as well. So if you look at India more locally, we have the ANI versus OpenAI case, which was filed late last year before the Delhi High Court, where ANI, which is again a news agency, is filing the lawsuit against OpenAI, suggesting that there is copyright infringement. Now, copyright infringement here again is at two levels, but the primary question before the court is whether the use of the plaintiff's copyright work, that is the news agency's copyright work, in order to generate responses amounts to infringement. So question is, the work that is generated, is it an infringing work, and is it infringing on ANI's copyright? Secondly, whether the defense of fair use could be taken by the plaintiff, right? And whether it falls under the defense of fair use. So though it is infringing, it can be a fair use exception. Now, this is ongoing as well, and you have multiple submissions by amicus who are which includes a professor from NLS as well, Professor Arul Skaria, who's submitted his views to the Delhi High Court, and you have Adarsh Ramanujam as well as an amicus who's filed his responses. So the court is asking for expert opinion with reference to this particular case, and this is the ongoing litigation again. But with reference to the foundational questions that it is raising, for which we need answers, not just in the context of ANI versus OpenAI, but also in the other US related cases, is this an act of fair use or not? And is your training data basically using copyright content unauthorizedly, or can such data and uh, text mining and basically even the concept of web scraping, can it be allowed as a fair use, right? So in response to these questions, you can either take the stance that, look, invariably copyright is infringed here, because if I am an artist who's generated artwork, or say the Ghibli studio itself, and today most of the content that is generated is in my style of work, that can be an act of infringement. Now, there again, the AI generator, or the basically the AI and its creator can take the defense that, see, even if I'm going to create images that look like Ghibli art, it's following the style. That's essentially not something that is copyrightable. What's copyrightable is the actual expression. And because here I am inputting certain images for which a Ghibli style image is generated, this will not amount to copyright infringement, because there is no direct infringement of the images that Ghibli Studio has created. I'm just following the style of artwork, and therefore that is even not protectable subject matter, and therefore my act will not be an act of infringement. Similarly, for say news agencies and the news that they use to report, and that being replicated in AI generated works or used unauthorizedly as training data, there can be a very strong case that you can make in the context of copyright infringement, saying that all of these are copyrightable subject matter. If I'm a news agency or a news paper who's publishing works, we have exclusive copyright over it. And just because it is available on the web does not mean that these can be unauthorizedly taken by these generative AIs and used to create text which largely replicates the source. That is, it's very much like my article itself. Can be an argument that that can be made in favor of the copyright owner. But there again, you can take the defense that this can also fall within the scope of fair use. And with AI, there is a lot of scope for innovation, and therefore stifling innovation or saying that you would have to pay a huge license fee to even use my data as a training data can be something which is counterproductive, because here you do not have the scope for the industry to grow as well as make knowledge more accessible. Because unlike information that is behind a paywall, which you can't access. Today, anybody can, with a smartphone, can very well use a generative AI tool to find answers for questions which might originally require you accessing content behind a paywall to find an answer. Right now, you can dispense with that in its entirety and find answers to questions for free, right? So this is also about knowledge dissemination, and therefore using copyright as basically a weapon to stifle all of this will also mean that uh, knowledge is not freely accessible to everyone. Uh, but again, this has to be taken with a pinch of salt, because not all AI generated content is accurate. Something behind a paywall might be authentic content, but we also know that AI hallucinates a lot. So there can be information that is misinformation as well, uh, which is very much possible with AI generated content. But again, if you're going to make all of these copyrightable content be used as training data, this misinformation also can be controlled to a large level, because here you can have content being generated which are uh, uh, authentic, which are true, because you have reliable source, which though falls under copyright, are available for usage through these generative AIs. Now, as long as it's not verbatim copied as training data and has paraphrased content that are created by AI generative tools, you can give some scope for AI to use these works and not use copyright as a weapon to stifle access to uh, proper information using generative AI tools. So it would be good if the courts decide on a similar vein as well, but that's left to be seen, because these cases are still actively litigated, and it's only time which will tell us whether the copyright owners actually succeed, or whether we can apply and extend the fair use defense in this context and say that in view of access to knowledge and access to information, considering generative AI facilitates that, we should allow for these copyright information to be used as training data as well. So I will end there and we can open up for any questions.
Thank you, madam, for a very detailed account of AI and copyright. It's really eye-opener for us, because as in academics, we tend to use, whether we or any of our students or in academia as a whole. So really, you made it very clear about AI-assisted and AI-generated. There's a very clear demarcation. I think that is the reason maybe some kind of help even the publishers are allowing now. But your point, which you mentioned, that if copyright material start appearing in AI, that will be much better, so that you will have a more kind of a authenticated content, which everyone, each one of us can refer. Now the forum is open for questions. So any of you have questions, you are requested to unmute yourself and raise the questions to the madam. Any questions? Madam, I have one question wherein that I'd like to raise.
Sure,
See,
sir.
recently there are some publishers, as compared to, as you told rightly, that copyright content, if it is made, paywall content, if it is made available on the AI. Like that, recently, Taylor & Francis and John Wiley, they had an undertaking licensing with OpenAI, wherein that they are licensing much of their written content to the OpenAI, but without the consent of authors, because they have not taken, but copyright lies with the publishers. So for the author, as a scholar, people like you and me, so wherein that we contribute with hard efforts to the publisher, but publisher, in order to make additional money, revenue, they are selling the content to this thing. What is that law? Whether is it going to protect the authors here, or it's because since they own the copyright, they are going
That's an
to.
excellent question, and I looked at economic rights, but not at moral rights. But to answer your question more directly, here, considering that these publishing houses are licensing the works, they have all the right to do so because we have given the economic rights, or rather assigned the copyright to the publisher, right? So if you look at the law, ownership vests with publishers, right? Unless and until if the author is saying I'm retaining the economic rights, that's a different story. Then they do not have the right. But in most cases, most research publications, they will have the economic rights because that's the bargain that they try to strike with authors. And as academics, we publish for other incentives, not so much monetary incentives, right? So they retain ownership rights, and consequently, them licensing for training data is definitely completely allowed. But the only catch there is, as authors, we still have certain rights that are not inalienable. So basically, we can't divest ourselves of those rights. Those are moral rights. And this includes rights like claiming authorship for my work, which means though the copyright owner is the publisher, I will always remain the author of the work. That cannot be changed. So if my content or my book is used as a training data for an AI because the AI has the license right now and it's generating content and it is citing my work but referring to somebody else as the author, I have the right to sue and say that because I retain the moral rights. Similarly, it can't make changes to my work as well. So as AI hallucinates, there's always scope for misquoting you or even like changing the contents of what is quoted as your work. Even there, you have scope to restrict them because that's again a moral right. Your work can't be distorted or damaged or changes cannot be made without your authorization. So those rights you retain, but nevertheless, the economic rights authorize the publisher to very well license it to anyone, including entities like OpenAI.
Thank you. At least we own the moral rights.
Yeah, we own the moral rights. Yeah.
I have one question.
Yes, ma'am.
I'm Vinita, and thank you for a wonderful lecture. I've attended a lot of AI workshops, but I wanted to ask you one thing. You said copyrighted data used by generative AI can be used for fair use?
So copyrighted data is used by generative AI, right? So the
Yeah.
copyright owner is saying my work is infringed.
Okay.
Right? Because you're using it, say, unauthorizedly without a license, as maybe Sir pointed out, right? There is web scraping, your work is taken without your authorization, right? So you're suggesting it's an act of infringement, right? What the AI does. But the AI in its defense can say, though it is an infringing use, it's not denying that it's taking your work. The fact that it is taken and infringing can, however, be exempted from infringement if it falls under a fair use defense. So fair use is taken as a defense by them to suggest that there are certain, for educational uses, you have fair use. There are umpteen other reasons for which you have fair use, like criticism, parody, right? So for those reasons, the usage of my content, even without my authorization, can be permitted. Okay, and therefore they're seeking that as a defense. I can't hear you, ma'am. I think you have to unmute yourself.
So there won't be any legal action.
Yes, or rather, there is a legal action. Their defense is it's fair use. So
Okay.
therefore should be permitted. So we can argue that you can take such a stance and courts can rule in their favor, suggesting in light of access to knowledge and information, such uses should be permitted. Otherwise, every data that a AI generating tool takes should be licensed, which means huge amounts have to be paid.
Yeah, correct.
Right? Yeah.
Yeah. Thank you.
Yeah, thanks, ma'am.
Is there any other questions?
I have one question.
Yeah, please.
Ma'am, can you tell us the difference between AI assisted and AI generated work?
So if you're really interested, you can take a look at the 2025 guidelines published by the US Copyright Office, which gives with details like images and everything, what's the difference between an assisted work and a generated work. But to put it simply, say if you're, instead of your prompts, you're giving a drawing, right? You're drawing something. and then you're inputting it in one of the image generating tools, AI tools, and saying that you enhance my drawing using these features and some other features which you're using as a prompt, right? But you've given an outline or a sketch. So that is your input. If that input is capable of being separated from the final output that the AI generates, then in the work that is yours, you can still have copyright. So though it is generated, there is some level of human assistance. This assistance can also take another form. That is, you generate an AI image, but then you make substantial changes to it, right? So where the final output is not entirely AI, but post AI generation, that is, there is your intervention, right? And as long as the US office, at least the Copyright Office, says that as long as it's separable and you can show the elements that are inherently only yours, um, then you can have copyright over that part of content which is yours. Or if it is generated and then you've made changes which are substantial, then you can have copyright over the work that is generated as well, because that becomes a AI assisted work. But as I said, you can definitely take a look at the 2025 US Copyright Office guidelines, because it has lot many examples of what can be an AI generated and an assisted work.
There is one question from a viewer who is watching on YouTube.
Okay.
So where that he's one Dr. Satish Munwale from Attract. So he's asking that how images produced by computers are accepted or copyrighted and not AI generated, because both are generated using computer only. That's what is the
Computer
question.
generated works, there is for instance in Adobe or something, you're making changes, or maybe say something as basic as MS Paint where you're creating a work, right? There invariably human input is there to a large extent, and because you are the person whose inputs are used to create the work, though computer is used as a tool, it is the human being who is creating the work, right? So it definitely will fall under the category of works that are capable of copyright protection. Unlike AI, where there is a black box, you're giving prompts, but what is generating is entirely AI's, right? Yeah. So therefore, there is a difficulty to make this clear distinction, and consequently, questions of authorship revolve around this as well. Yeah.
Got it. Got it. If we don't have any more questions, I think then we'll end the webinar. And on behalf of IGIDR and on behalf of the director and the registrar and we all of us, thank you very much, madam. And on behalf of all other participants who are watching on YouTube. So we thank you very much for your very elaborative kind of a thing on AI and copyright, where we stand today. And also you give a very exhaustive case list where that including the Indian case of ENI versus OpenAI. I know that many of the cases are still in the courtroom only, so we don't know what would be the outcome, as you rightly pointed out, because everybody is trying to play around fair use. I think where in that, but one thing, good thing is that it is given only where the human involvement is there. So that is really nice of it. But only thing is, I'm worried that now agent-based AIs are coming where that AI co-scientists, for example, Google has developed a tool wherein that it is going to work along with you. So I don't know where I think maybe only the time is going to.
Time will tell us, yeah.
Thank you very much, ma'am.
Thank you so much, sir, for your patience as well over organizing this, and thanks for inviting me and having me here. Thanks so much.
Thank you so much.
Good day, ma'am. Thank you all. Thank you very much.